Welcome, everybody, to Vermont House General and Housing. Today is Wednesday, April 9th, and we have a full morning of hearings. We're gonna start with the hearing on 334, which is an act relating to limiting employer restrictions on individuals separating from employment, specifically non-compete clauses, stay or pay clauses. And we have 4 witnesses this morning. We will continue hearing on this probably next week. And so, gentlemen, I see you're all with us electronically. Pat, you're first, and Brian, you're second, and Sebastian, you're third, and Winston, you're fourth. Is that all right? Is that order fine with you, gentlemen? So I'll tell you what we'll do. We'll have the committee introduce itself to you, although I can see what you can see and you can barely see, but we'll do that anyway. You want to start?
Sure. Good morning. I'm Ashley Bartley. I serve Fairfax in Georgia.
Joe Parsons, Newberry, Topsom, and Groton. Don Charlton, Athens, Chester, Grafton, and Wyndham.
Representative Debbie Dolgan from St. Johnsbury, Concord, and Kirby.
Gail Pezzo, I represent Chittenden 20 Colchester.
I'm Mary Howard. I represent Rutland City District 6.
Good morning. I'm Elizabeth Burrows and I represent Windsor 1, which is Heartland, West Windsor, and Windsor.
Emily Krasnow, Chittenden 9, South Burlington.
And I'm Mark Mahaly, and I represent towns north of Montpelier, Calais, Plainfield, and Marshfield. And I can tell you that the committee actually almost accidentally represents a broad swath of Vermont. Lots of different, very rural, very urban, or urban for us. So we can see you quite clearly and hear you well. So Pat, introduce yourself for the record and take it away.
Absolutely. Chair Mahaly, Vice Chair Bartley, and members of the committee, thank you so much for listening to my testimony today. My name is Pat Garofalo, and I am the Director of State and Local Policy at the American Economic Liberties Project, a research and advocacy organization dedicated to reducing the power that dominant corporations wield over our economy and democracy. I'm here in support of H334, which would prohibit the use of non-compete agreements. Doing so is a key step toward ensuring that workers are able to access good, high-paying jobs, and that corporations are not able to use their power to unfairly lower wages or working conditions for Vermont employees. About 1 in 5 workers nationally is bound by a non-compete, meaning tens of thousands of Vermont workers are potentially affected by these agreements, which limit or eliminate their ability to accept a job within their chosen field, usually within some geographic distance or for a set period of time. While non-competes have historically been limited to highly paid executives or partners in a business, they've expanded far beyond that in recent years into industries such as fast food, healthcare, and custodial services. They are often imposed without workers realizing what they've agreed to, or imposed under economic duress, without the employee having the time or legal expertise to analyze what they're signing. These contracts can make it very difficult, if not functionally impossible, for workers to find a new job or leverage job offers they receive into better pay or working conditions at their current employer. Because, as I'm sure you all know, there are many factors that can bind workers to a place, including family and childcare obligations, they often can't get outside the range of a non-compete to take a new position, limiting not just their ability to find a new, better job, but also their ability to start their own business in their chosen field. Combined with increasing labor market concentration, this gives employers a powerful ability to restrict wage growth, degrade working conditions, and prevent competition from new innovative firms. While workers and prospective small business owners have no recourse other than uprooting their lives, changing fields, or going without work for an extended period of time. To that end, extensive research has shown that non-compete agreements stifle wage growth, innovation, and job creation, and raise prices for consumers. The Federal Trade Commission estimates that banning non-competes would increase wages for Vermont workers by more than $127 million annually, or about $528 annually per worker. Non-competes are especially pernicious in a field such as healthcare, where an inability to change jobs or start a new facility or service can have negative effects not just on the employee, but on the community as a whole. As one Vermont employee said of their non-compete, quote, "I am a pelvic floor specialist in the state of Vermont. I have certifications, trainings, and a doctorate education. I'm currently being held at a place of employment due to a non-compete that I signed, regrettably so. I would love to be able to offer and extend my services to more rural areas of Vermont, but unfortunately, my hands are tied," end quote. 5 states, Oklahoma, Minnesota, North Dakota, Wyoming, and California functionally ban most non-competes, while most other states have some limit to their use. Wyoming's ban was adopted just a few weeks ago, passed by a Republican legislature, and signed by a Republican governor.
I'm sorry, which state?
Wyoming.
Yeah.
The FTC has also proposed a rule that would ban nearly all non-competes, but it is tied up in court and may well be rescinded by the current commission, meaning it is more important than ever that states adopt their own rules to prevent the abuse of these contracts. Now, opponents have cited the need to protect trade secrets or other proprietary information as a reason to continue to allow the use of non-compete agreements, but this is a false choice. Other contracts, including non-disclosure agreements, can be used to protect proprietary information without resorting to the blunt instrument of a non-compete. In fact, the FTC has said that it is, quote, not aware of any evidence non-compete clauses reduce trade secret misappropriation or the loss of other types of confidential information, end quote. So I urge the Vermont legislature to pass H.334 and ensure Vermont workers are able to determine their own economic futures for themselves. This is a policy with wide-ranging, bipartisan appeal whose time, quite simply, has come. Thank you for your time, and I'm happy to answer any questions.
Thank you. Members of the committee.
Yeah. Yeah, I believe you said 1 in 5 workers is under a non-compete. Is that a Vermont number or is that a,
That's a national estimate, so
do you have anything for
6,000
Vermont?
somewhere in Vermont. I don't have a specific Vermont number, though someone else on the panel might.
Okay.
Do you
thank you.
think there is a Vermont number? Pat, I mean, and is it something? You have any knowledge? You're citing Vermont a good bit. So do you have any sense as to whether there might be a Vermont number?
I don't, and it may be hard to get an exact number because, as I said, oftentimes workers don't even know they've signed these until they're being enforced against them. So it can be a little tricky to get an exact number. But that 1 in 5 number kind of holds across states. So I would guess it's somewhere in there, but I don't have an exact number for you. But again, I defer to some of the other members of the panel.
Go ahead. I'm sorry I just wanted to follow. Do you have more questions?
I'm done.
You're done.
Thank you.
Other questions of Pat? Hey, Pat, thank you so much for testifying. Where are you, by the way?
I am based in Washington, D.C., the very perfect place to work on state policy from, obviously.
Yeah, right. My condolences. All right. Next, thank you, Pat. Brian?
Hello, good morning. My name's Brian Kalachi, and I'm the chief economist at the Open Markets Institute. And we're a research and policy organization focused on anti-monopoly policy, headquartered in Washington, D.C., although I live in Peekskill, New York, and I'm from Rhode Island. So my PhD in economics is from the University of Massachusetts Amherst, not too far from Brattleboro, and my research focuses on the effects of restrictive contracts imposed on workers and small businesses. And I would really like to thank Chair Mahoney and the other members of the committee for the opportunity to participate in this hearing. We at Open Markets support banning non-compete clauses and similar provisions in labor contracts, including stay or pay and training repayment agreements, because these prevent workers from changing jobs to work for the employer of their choice or to start their own businesses. And by limiting worker mobility, non-compete clauses drive down wages, they reduce the formation of new businesses, and they trap workers in jobs where they may be subject to unsafe working conditions, discrimination, or abuse. So H.334 would prevent employers from imposing these really pernicious contracts for all workers, which is something we have been advocating for some time. In March 2019, the Open Markets Institute led a coalition of civil society organizations, labor unions, legal experts, and economists that formally petitioned the Federal Trade Commission to use its authority under the FTC Act to issue a rule prohibiting non-compete clauses in labor contracts as an unfair method of competition, making it per se illegal. A year ago, the FTC enacted a rule to do just that. But as Pat mentioned, it's currently facing legal challenges. So H.334 is really important, and things like H.334 because it'll safeguard the rights of workers, consumers, and small business owners in the event the FTC's recently enacted final rule is struck down by a court or rescinded. And H.334 also offers the opportunity to close important loopholes in the FTC's final rule, such as the stay or pay contracts, and provide workers with additional enforcement channels to the FTC's admittedly sometimes cumbersome administrative process. So even if the final rule is upheld, this law will add a lot of value. Now, I'm going to stick pretty much to my wheelhouse, which is economics. And here, the economic research is very clear. The evidence strongly demonstrates the harms from these kinds of contracts, non-compete clauses. The use of non-compete clauses reduces labor market mobility and generally depresses wages, wage growth, and small business formation. I can provide any citations or documentation if that's desired. It affects as many as 60 million private sector workers nationwide. And one of the reasons, to follow up on the questions for Pat, it's difficult to get an estimate is because you have to survey workers or survey employers to figure out who's subject to these contracts. So I'll ask actually some of the economists who have worked on this if that would be helpful, and see if they have more granular data for Vermont. But one of the issues there is small sample size. It can be difficult to get, but I can follow up. But anyway, the FTC estimates that these contracts cost workers between $250 and $295 billion per year. Again, nationwide number. And yeah, they're imposed on workers. They're not negotiated. So the national survey that we have done found that only 10% of employees negotiate these non-competes, and 1/3 are presented with them only after accepting their job offer. So, you've done all the interviews, you're sitting down for your HR packet, and there's a non-compete clause in there. No one's going to turn that down, and that late in the game. So non-compete contracts and similar contracts that limit worker mobility, they do suppress wages. A recent study of the 2008 ban by the state of Oregon found that banning non-competes increased wages by 14 to 21%. That's a pretty substantial number. Another study found that wages of tech workers rose 4% after non-competes were made non-enforceable just in that sector in Hawaii. And in particular, the adverse effects of restrictions on labor mobility, they appear to be especially pronounced for women and people of color. Recent research has found that stronger enforcement of non-compete clauses reduces earnings for female and non-white workers by twice as much as for white male workers. And it's not just workers who are harmed by non-competes. Employers' use of non-compete clauses also has adverse effects on competitors and consumers in product and service markets. The use of non-competes by incumbent corporations for specialized workers slows the entry and growth of new firms, affecting economic dynamism. For example, with non-compete clauses, employers can foreclose competitors in downstream markets. They can tie up workers that have particular skills with these clauses, preventing new companies from entering and small companies from hiring the labor they need to compete effectively and grow. So they cement monopoly power and cement market dominance. So there's been recent studies found that just an average size increase in the enforceability of non-competes reduced the mobility of inventors by 22%, and it reduced patenting by 13 to 20%. And that same Hawaii law I just mentioned that made non-competes enforceable for technology workers, once that was in effect, there was a 10.2% increase in the number of technology establishments. So these non-competes prevent workers from starting their own businesses. And this kind of monopoly power can inflict significant and durable injuries on consumers. So it's not just workers who end up paying higher prices and that are deprived of higher quality goods and services. And that really matters when we're talking about things like healthcare, things that people really need to survive, literally. The FTC estimated that banning non-competes would lower the spending on physician and clinical services by calculating, this is a lower estimate of the present value savings over 10 years at $74 to $194 billion. So finally, I would just like to address some of the reasons given for non-competes. So the harms for non-competes, they're real and well documented. There's a very large economic literature on this by now, but the justification is frankly very unpersuasive. Employers and representatives sometimes assert that non-competes are necessary for protecting trade secrets, customer lists, and other business information. Pat covered this earlier. I was at a couple of extra facts. And according to this theory, restricting worker departure is necessary to prevent workers from appropriating the know-how and taking it over to rival companies, or taking something they learned and starting their own business. But to the extent employers do need to safeguard proprietary information, they do have less restrictive alternatives for preventing unauthorized disclosure. There's copyright law, there's trade secret law, there's targeted non-solicitation agreements, and those laws are there to protect valuable information and prevent it from being disseminated. H.334 actually makes explicit allowance for such contracts. And for really high-level workers who have regular access to sensitive information, employers also have the ability to opt out of at-will employment and enter into fixed-term employment contracts that commit both parties to the relationship for a period of time, like we see in professional sports or in some of the entertainment industries. And so in contrast to these other methods for protecting secret information, non-competes they're the wrong tool. First of all, they're overbroad. They restrain worker mobility with the aim of protecting business information, even if it's dated. You can't leave your job because of a training manual you got 5 or 10 years ago. And at the same time, they're too narrow because non-competes don't prevent unauthorized covert disclosure of trade secrets to competitors during the employment term. So they're just not the right tool for those kinds of purposes. And the final argument I want to address before I close is there's an argument that they reduce employee turnover and promote the employer investment in worker training. By barring workers from leaving and taking their skills to rivals, non-competes give employers the incentives to train workers, and that ultimately benefits both parties. But that doesn't hold much water because, first of all, by the same token, non-competes also would lower workers' own incentives to invest in their own training. Why would you try to learn new skills at your current employer if you can't find a new job and get fair value for them? So the worker will reduce their own investment in training. But second, and we actually have very good empirical evidence for this, when non-competes are banned, employers don't just give up. They find other better ways of retaining a loyal workforce and protecting mutual investments in training. They offer higher wages. They offer better working conditions. And most importantly, they offer stability, the promise of future promotion and wages contingent on good performance. So when workers are prevented from using non-competes, they end up raising wages. Some of my own research has shown that with no-poach agreements. So when Washington State banned non-competes for employees earning less than $100,000 a year, employers who really wanted to use that non-compete to keep workers at their jobs would have then, if you're paying someone $98,000, you would have bumped them up to 100, so you could take advantage of the non-competes. But workers didn't. Employers actually didn't do that. We didn't see those effects. So. And for the very last page, the last paragraph, given the documented injuries to workers for non-competes and the specious employer justifications for their use, we support a categorical ban on these contracts like the one in H.234. And we would encourage Vermont to maintain the universal approach and not include carve-outs like other states have done, tied to income or the line of work or the employment status. Thank you for your time. I'm happy to take any questions.
Questions of Brian? I have a couple questions, Brian. Who were the plaintiffs in the FBC case? Or what was their nature?
Yeah,
I
so
don't mean like specifically, but like, were they chambers of commerce? What were they?
Oh, I see. In the challenge to the rule.
Yeah.
It was there's two challenges. These plaintiffs, I believe, have been they were mobilized by the U.S. Chamber of Commerce, but there's one is, I think, a landscaping company in
but that's actually,
Pennsylvania. And the other one, I forget, Villages. If anyone on the panel knows, but I forget who the actual
Chamber of Commerce. I just wanted to know who was dissatisfied. And to your knowledge, have you seen any litigation on the other side challenging non-competes on the grounds that they're unconscionable or that they're adhesion contracts? Have you seen anybody challenge non-compete successfully?
Yeah. So the current legal test, and with the caveat that I'm not a lawyer, I'm just an economist. But the one of the reasons why the law, it's important for statutes and the FTC rule to ban these is because they end up being challenged under rule of reason adjudication under the antitrust or under unconscionability laws, which require plaintiffs to hire, in some cases, very expensive economic experts to show the damages. And because the evidence is overwhelming, that these contracts have very little justification and are harmful. We think it's important to just ban them. But yeah, there has been workers without a law banning it. Workers are able to file lawsuits, but they face pretty stiff legal barriers because of they have to prove unconscionability, they have to prove unreasonableness, and also and again, most workers. The final point I would make is that workers, even I have a PhD, and if I sign a contract, I assume it's enforceable and I have to obey it. I don't go looking for a lawyer to find out how I can get out of it. So even highly paid workers, when they sign a non-compete, generally won't challenge them because, hey, I signed a contract. The contract is a contract.
Thank you. Any other questions? Brian, thanks a lot for your testimony. Appreciate it. Sebastian, you're up.
Thank you. Good morning. And I'm going to share some slides in a second, but I want to say thank you for the opportunity to speak today, Chair Mihaly and members of the committee. My name is Sebastian Martinez Hickey. I'm an economic analyst at the Economic Policy Institute, which is a nonprofit, nonpartisan think tank that's dedicated to doing policy research focused on low and middle income workers. So we analyze policy and we propose policy that we think is going to protect and improve the economic conditions of those workers. And I'm speaking today in support of House Bill 334. So if you give me a second, I will share my slides. Are those visible for everyone?
Yeah, that we can see them.
Thank you.
Yes,
Woke me up.
As Pat and Brian have gone over already, businesses justify non-competes in a couple of different ways. They claim that they are needed to protect trade secrets and client lists. They also claim that they are needed to protect the investment that businesses put into training workers. But as we come to understand, these types of agreements have become pervasive across the economy, and they're often used beyond any legitimate justification. Under the status quo that we exist in right now, existing firms benefit from the widespread usage of non-competes because they limit their employees' outside job options and thus increase their ability to negotiate pay with those employees. And they limit the ability of new firms to enter into the market and challenge the market share of existing firms. Who loses or who's disadvantaged under this scenario? Workers who are paid lower wages, would-be entrepreneurs who cannot or are more limited in their ability to start their own businesses. And in aggregate, this can affect a state's economy like Vermont's as a whole, as it's denied higher productivity firms, greater business competition, and stronger wage growth, which can result in increased consumer spending in the state's economy. So Pat said earlier there were 1 in 5 workers. Other studies say like around 1 in 4 workers are subject to non-compete agreements. I don't have Vermont specific data, but if we were to bring this figure over to Vermont, it'd be around 87,000 workers in the state that were subject to non-competes. It's often assumed that non-competes only affect high wage workers in knowledge-specific occupations, but this is not the case. Non-competes often target low-wage workers who have no access to anything resembling a trade secret or a unique client list. Nationwide, around 14% of the workers earning less than $20 an hour have non-compete agreements. To provide a little bit more texture to both of these claims, this is a table that breaks down the prevalence of non-competes by workplace industry at the national level. So you have the industry grouping and then the share of workplaces where all employees are subject to non-compete agreements and the share of workplaces where any employees are subject to non-compete agreements. You'll see that business services has a disproportionate or a higher level of the prevalence of these types of agreements, but really they are widespread throughout the economy. For example, more than a quarter of the retail trade workplaces in this study subjected all their employees to non-compete agreements. This is a breakdown of the same study, but by the average hourly pay of the employee in each workplaces. And again, we see that non-competes are quite common for low-wage employees. If you look at the category that's $13 an hour to $17 an hour, more than half of the workplaces in this study subjected at least some of their employees to non-competes. And what the asterisks are indicating here is that that is significantly higher than the average for all workplaces. And this type of finding has been confirmed by other research. For example, economists from the Federal Trade Commission and the University of Maryland found that the modal or most common worker with a non-compete is an hourly employee earning around $14 an hour. Non-competes lower wages for workers. It's important to remember that the only source of leverage that a non-unionized worker has over their employer is their ability to quit and find a new job. Non-competes kneecap this leverage by definition, and as a result, they lower wages for workers. Evidence across a group of studies find that these agreements decrease wages by between 2 to 3%, 4%, and other marks. This wage effect is for all workers in the industries where non-competes are common, not just the workers that have actually signed the non-compete. And as Brian mentioned, the evidence is also greater The evidence also shows that these negative wage effects are greater for women and Black workers than for white men workers. Going back to an argument that I mentioned earlier, some firms argue that they need non-competes because they train their workers on the job and they need to make a return on their investment. The economic research finds that the gains in wages that workers receive from this training is usually outweighed by the wage suppressing effects that I've detailed here. It's also notable from an economic theory perspective, since non-competes actually lower the wages of workers, it shrinks the pool of available workers for particular jobs. So there might be instances where by high pay or wages, you actually increase the number of workers who are willing and able to work at that wage level. And you might find workers who who already have the experience or don't need the training that is needed for the job.
Sebastian, I have a question for you. Actually, it's for any one of you. I imagine you've had the opportunity to read non-compete provisions and contracts, right?
I'm not a lawyer and I'm not super familiar, but I can do my best to try to answer your.
Well, do you happen to know whether they apply if someone's been fired?
We do.
I don't know the answer to that question.
Okay,
They do.
they do.
I can
All right.
briefly speak to that and I'll address it in my testimony coming
Okay.
up. But in general, I mean, they of course vary on the actual terms, but there are non-competes and stay or pay provisions that apply regardless of the nature of the termination.
Okay, thank you.
Thank you, Winston. Yeah, so non-competes, they're claimed that they are necessary for incentivizing innovation by protecting trade secrets, protecting proprietary information. But these contracts actually hamper economic dynamism. They prevent would-be entrepreneurs from leaving their current employer and creating their own business. One study found that banning non-competes would boost business formation by around 3%. Another study showed that when non-competes are enforced more strictly, patenting decreases by between 11 and 19% over the course of 10 years. And that includes significant decreases in what are they describe as breakthrough innovations, the key technological innovations that are then built on by further patenting. So again, this is stifling for the economy. As Brian detailed, I think quite well, businesses don't need non-competes to protect trade secrets because there's already intellectual property rights systems that protect this type of information. California has made it illegal to enforce non-competes for more than a century, but it still has a lot of global research and technology hubs that don't need non-competes to be successful. It's also worth noting that, actually, let me just go to the next page. I have one more point to make is that in the states where non-competes are unenforceable, employers still use them and they still have a depressing effect on wages because most workers aren't going to know whether the contract that they've signed is illegal or unenforceable. So it's important that the state considers establishing real penalties and proactive enforcement mechanisms to deter employers from attempting to use them. Although I think that House Bill 334 has good language around making sure that employers disclose that these contracts are unenforceable and void. And then just one last comment to make about the general state of state policy. Most states have some sort of restriction on non-competes, but there are 5 states with effectively full bans: California, Minnesota, North Dakota, Oklahoma, and Wyoming. California, Minnesota, and Wyoming have recently passed those bans, whereas North Dakota and Oklahoma both have very long-standing bans on this type of policy. And there are also a group of states that heavily restrict or they prohibit non-competes for workers below a certain income threshold, which tries to decrease their usage for low-wage workers. So, in summary, non-competes, they reduce wages, they reduce job mobility, and they cost the economy by reducing the efficient matching of workers to high-productivity firms. So for that reason, I urge the committee to pass House Bill 334. Thank you.
Thank you. Questions of Sebastian? Yes, go ahead, Ashley.
Thank you. My question, so you had mentioned, and I think a few others have mentioned, legitimate concerns of an employer. What would you consider a legitimate concern for an employer to constitute a non-compete?
Well, I think Brian really articulated this well. I think there are legitimate concerns about protecting trade secrets for a business, but there are other types of contracts that can be used to protect that sort of arrangement. And I think, House Bill 334 is written in a way that prevents or allows non-solicitation agreements, non-disclosure agreements that are important for protecting intellectual property rights and other types of business information.
In other words, none. Other questions? Thank you, Sebastian. Appreciate it.
Thank you.
Winston, you're on.
Great. Thank you so much. Thank you, Chair and members of the committee, for the chance to testify. My name is Winston Berkman-Breen, and I'm the legal director at the Student Borrower Protection Center. We're a nonprofit legal organization focused on alleviating the burden of student and worker debt for millions of Americans. I'm especially excited to testify with you all today, although I'm not from Vermont. I'm zooming in from Brooklyn. It's an adoptive home for me. My parents live in Plymouth, Vermont, and my sister in Cavendish, both in Windsor County. So great to be with you in spirit, if not in person. So today I'm going to focus, my colleagues have addressed non-competes more broadly. I'm going to focus on the stay or pay provision of the bill. I'm going to start by providing some background on stay or pay terms as a coercive employment tool, and then I'll discuss recent federal efforts to regulate these provisions, and we'll conclude by giving some feedback about the specific proposals in H 334. We'll have plenty of time for questions. The basis of my testimony today is from our work at the Student Borrower Protection Center. We're litigating several cases against the enforcement of stay or pay terms. We published several reports and legal articles on the topic and regularly engage in legislative and regulatory advocacy related to stay or pay provisions. As the term suggests, stay or pay provisions are employment contract terms that force workers to pay their employer if they leave their jobs. Full stop. In this way, stay or pay terms can be more pernicious than their cousins, non-compete provisions, since it doesn't matter why you leave or what or where you go to work, or even if you work. No matter what, if you leave, you have to pay. This builds on an existing power imbalance in the workplace. Employers can still terminate workers at will, but under stay or pay terms, workers cannot financially afford to exercise their reciprocal right to quit at will. These terms are forced on workers as a condition of employment, allowing firms to use the threat of debt collection or litigation to lock workers in place, limiting their mobility and bargaining power and preventing them from leaving. When they do leave, workers are hit with crushing financial penalties just because they had the audacity to quit. This puts workers in a bind to stay and endure unlawful or unsafe working conditions, which regulators, lawyers, and judges have suggested create unlawful modern-day indentured servitude, or leave and face a financial penalty. So for example, a student trainee truck driver accepted a job, these are all true examples, accepted a job that included a stay or pay provision. She was then sexually assaulted on the job. When she reported it to the company, they failed to take action and she subsequently quit. They then tried to collect $9,000 from her. Another example, a recent nursing school grad took a job at a hospital in a neurological ICU, seemed like a dream job, but the unit was short-staffed and his training was cut short by a month in order to help, free him up to fill some staffing gaps. He was then also asked to train the newest nurses, even though he didn't feel as if he'd been trained on the content he was supposed to teach. He felt that working conditions were unsafe and that he couldn't provide quality care for his patients, but he was afraid to speak up and leave because his employment contract included a $7,500 stay or pay provision with a 12% interest rate if that provision was activated. When factoring in his $35,000 in nursing school loans, he just financially could not afford to leave or to cause trouble. So firms ranging from hospitals to roofing contractors are harnessing stay or pay contracts in an attempt to evade state and federal worker protections, including state-level bans on non-competes, which some of my colleagues just spoke about. One trade association for roofing contractors openly advises in a publication that its members use stay or pay provisions in jurisdictions where traditional non-competes are banned. One of the most common types of stay or pay contracts is called a training repayment agreement provision, or TRAP, T-R-A-P, which have become increasingly common since the COVID-19 pandemic and are often presented as a condition of employment and require workers who receive so-called on-the-job training, regardless of the quality or necessity of that training, to pay back the supposed cost of that training if their employer, if they ever leave their job, they have to repay their employer. a few more examples of these sort of trap stay or pay provisions. So I've spoken with a licensed career esthetician in upstate New York, 20 years experience, who left a beauty salon only after 3.5 months due to a toxic work environment. Her employer then sued her in local small claims court for $5,000, claiming that this was the price of the training she received in her salon. The training was showing the career esthetician the way that the salon owner preferred someone to thread eyebrows in her shop, and doing it on paying customers. This was all for a job that only paid $14 an hour, mind you. Another quick example, where we've helped someone who attended PetSmart, the pet chain store. PetSmart operates something called a grooming academy, which promises free training in dog grooming. But hidden in that promise is a condition that if you leave the PetSmart network within 2 years for any reason, you then owe them $5,000 for the supposed cost of that free training. The training does not result in a certification or license, just a printed out computer diploma from PetSmart. The worker decided that she needed to leave PetSmart because of unhealthy working conditions and low pay. And soon after that, she saw a $5,000 debt posted to her credit report from PetSmart. We're also in litigation representing a cargo plane pilot whose former employer is seeking $20,000 for the supposed training she received, even though the training is required by federal law and is not transferable to another employer. And so the benefit of that training is really with the employer, not the pilot. So in other types, these are just a few examples, but in other types of stay or pay contracts, employers have demanded that departing employees pay them for not providing 4 months notice of resignation, for the cost of their replacement, for liquidated damages, or even for lost future profits. So traps also, in addition to sort of shocking the conscience, traps also violate fair wage and labor laws, which generally require that wages be paid free and clear, and that they be above or at the minimum wage. The existence of a trap, for example, means that wages are not in fact free and clear because they're effectively conditioned on the worker staying for that prescribed period of time in the trap. And if the worker leaves and the trap payment is demanded, that has the practical effect of suppressing, when calculated all together, suppressing the past wages and often bringing them below the minimum wage amount. So as my colleagues on the panel have mentioned, it's actually very hard to quantify the total number of these provisions out there because they're all private contracts. You'd have to survey them or otherwise compel contracts to be submitted and reviewed. But so there's no definitive database or statistic, but I think it's also very clear that these are ubiquitous across industry types, job types, geographies. There's really no question that Vermonters are subject to some form of stay or pay provision in the same way that they are subject to some form of non-compete. So very briefly, I'd like to talk about what's been happening at the federal level around stay or pay provisions, especially in the last 2 years. So the former National Relations Board General Counsel, Abruzzo, issued a memo in October of 24, last fall, explaining that stay or pay terms violate federal worker protections because they, quote, have serious potential for suppressing union organizing and other concerted activity for mutual aid or protection, including by impairing job mobility, end quote. She also noted that, quote, employers have used these provisions as coercive restrictors of employee mobility, which is not a legitimate business interest. The U.S. Department of Labor sued a company called SmoothStack, which is an IT staffing agency, for trapping employees in their jobs by demanding they pay up to $30,000 if they leave the company before completing 4,000 hours, which is roughly 2 years, of billable work, causing some employees to earn less than the federal minimum wage, which is a violation of the Fair Labor Standards Act. The Fair Trade Commission defined traps in the rulemaking you heard about last year as de facto traps and stay or pay generally as de facto non-competes in that final rule because of how they unfairly limit competition and restrict mobility. Again, as you've heard, that rule is currently being challenged. Finally, the Federal Consumer Financial Protection Bureau issued a report highlighting how traps and other types of employer-driven debt can actually violate consumer protections as well. So although there's been a lot of activity and it's encouraging to see, much of this has been rolled back or enjoined, and we don't candidly expect to see much more progress on the federal level on stay or pay or trap issues. So for this reason, it's really important that states step in, and so I applaud you for that. So just to conclude, I want to talk very briefly about H334 itself and some of the specific stay or pay provisions. Again, I applaud the sponsor and the committee and the legislature for hearing this. It's a very timely issue. That being said, I do want to call attention to a concern I have about the stay or pay portion, which is an exemption found in 495R subparagraph C, which I think serves as a loophole that could really be abused to allow effectively all stay or pay provisions to remain in place even once the law is enacted, specifically focusing on the voluntary agreements and the reasonable cost part of that exemption, which I believe put individual workers at a disadvantage. So allowing for voluntary agreements, voluntary stay or pay agreements, really overlooks the inherent power differentials between employers and workers and the fact that employment agreements are essentially contracts of adhesion for workers, and they really can't meaningfully bargain or negotiate. And focusing on reasonableness, as I think Brian mentioned, creates just a vague standard that's going to be very difficult to administer and require lengthy and expensive individualized litigation. So in the alternative, to the extent that the legislature does want to include specific employment benefit contexts in from the bill's coverage, which is to say allow certain types of employer repayments after the bill is in effect, I suggest putting in much more specific and explicit and narrowly tailored protections that follow the following three sort of guidelines or protections. So the first is any agreement to repay an employer should be limited to instances in which there is an actual bona fide benefit conferred to the worker rather than the on-the-job training for the worker's current job or the job they're applying for, which we would expect them to get as an employee of a firm. Second, any agreement to repay should be in a standalone agreement separate from the employment agreement to ensure that workers can accept a job without also agreeing to receive and pay for a benefit that they may not want, especially since the benefit shouldn't be necessary for that job itself. And finally, the bill should include strong protections against payment obligations in the case of wrongful termination or termination for no cause or constructive termination to protect against toxic work environments and abusive employment practices. So for example, if an employer offers to cover a worker's tuition for like an accredited degree, like, you know, you can go get your MBA or nursing degree, but you have to come back and work here for 2 years first. Otherwise, you have to repay me. That scenario, I think, should be more narrowly tailored and put into the bill explicitly, as opposed to the factors that are currently there. So I'll end there. Thank you again for the chance to testify and for considering this bill, and I'd be happy to answer any questions.
Questions? Tom?
Sort of a high level philosophical question. How would you consider work in public service as an agreement to have your student loans forgiven? If you leave that before 10 years, you're paying your loans.
That's correct. You're paying your loans, but you're not paying anyone back. That's the huge difference here, right? So under the federal
government, you're paying the Department of Education, you're paying somebody back.
But you're also paying them during that whole time. So if you're paying, it's a 10-year program, you have to make 10 years worth of payments. If for some reason after 6 years you switch into the private sector, you just keep making payments on your loan. So you're paying as you go. It's a pay as you go sort of program, and they cancel any remainder. So no one is covering that cost for you during that program. It's a great question. And candidly, in this context, stay or pay, we hear that a lot, usually as a sort of red herring by some industry actors who are trying to say this will disrupt these existing programs. These programs, although similar in that they relate to employment and debt, are distinct in how they're structured.
Okay, so if a job requires specialized training and the employer says, you go get the training and you pay for the training and then apply for the job, which I think would be pretty typical. Is that always to the benefit of the employee?
It's hard to answer these questions in the abstract, but in an instance where there is a type of training or certification that the employee gets that they then have and is transferable from job to job to job, there's an argument for saying that the employee should foot the bill for that. If it is so specialized that is just to that employer, then the argument is that the employer should be the one footing that bill as necessary training for that job that really can't be brought or transported somewhere else.
So for example, you would think, let's say a condition of employment is that you have a commercial driver's license.
Mm-hmm.
You would think, according to you, that's a legitimate requirement for an employer to say you go for that on your own, or if they want to pay for it, if you leave, you gotta pay us back the cost of getting that commercial driver's license.
I think that's a good example where you can argue that repayment might be fair, but then it's really important to have those consumer protections about abusive work environments. Like what we don't want is that scenario where, sure, the employer footing the bill for the CDL seems appropriate, but then it's, you know, you're getting sexually harassed on the job and you have to leave for your personal safety, and then somehow that still triggers the repayment obligation, right? So it's a combination of when is it repayment appropriate, and where are we going to have a safety net or release valve for instances where the employer has misbehaved and repayment in that instance is not appropriate despite the training.
Do you have language that you could provide us on this last piece on your hesitation about 334?
Certainly, I'd be happy to follow up with the sponsor committee staff to provide some language.
Could you send it to our committee assistant who has been corresponding with you already to arrange your testimony?
Absolutely, yep.
Thank you. Other questions? Tom?
Another question. When it comes to trade secrets and proprietary information, several of you have mentioned that there are other means to protect that or to remediate damages. Are there not also other means to deal with workplace harassment?
I think there are, but the question is whether in addition to doing that, are you being saddled with debt at the same time, right? Like in certain work, at least this is true for the stay or pay provision. I can't speak as much to the non-compete, but in any of the instances that I cited or others you can imagine, someone needs to remove themselves from that scenario, right? They're being sexually assaulted, you know, they just can't be involved with a 50 patient caseload on a hospital floor or something to that effect. There may still be recourse against the employer, but at the same time, they shouldn't have $7,500 showing up on their credit report.
Right, but is there any thought to what do they have any responsibility to exhaust other options before leaving an employer with a $9,000 training bill? Should they not pursue these other, you know, labor protection provisions?
Yeah, I would say no. Thank you for the question, but I think that this is actually a really good instance for why it is problematic for employers to get into debt issues and sort of blur the line between employer and creditor. Anyway, these are sort of separate and rather siloed areas of law, sort of consumer protection, worker protection, and the harm that can be caused by it suddenly throwing a debt, whether it's $7,500 or $30,000 on someone, can be pretty irreparable to their credit, to their ability to sort of make monthly payments that are necessities, rent, food, etc. So I don't think that having an administrative procedure requirement that puts a lot of onus on the individual to navigate that, it can be expensive as well, before they can be protected from a financial burden, is sort of justified by the fact patterns we typically see.
Yeah, I'm not arguing that the ability to get away from the stay or pay provision shouldn't apply in that case, but as an alternative to doing anything else about the situation.
Oh, yeah, I certainly don't.
Just not dealing with bringing charges or, pursuing the other venues of the law to protect an employee. Just disregarding those things and leaving. I have to think about that.
Yeah. And if I understand your question correctly, it is my understanding, I don't think the intent or the language of the bill would preclude someone from also taking those sort of more traditional steps.
But you're saying, Winston, I just want to clarify what you're saying in response to Tom's question. You seem to be saying, okay, there's a body of law that lets an employee claim harassment. It's true, it might be burdensome to pursue it, but what you're saying is, absent a stay or pay agreement, an employee can decide, I don't want to work there while I spend a year or two pursuing my harassment claim. But that if there is a stay or pay provision, they kind of have to stay.
Or pay, that's exactly right.
Or pay, yeah. The alternative is though, let's say they win, they do say, and they win harassment action and leave, they'd still have the success of the harassment action. Would the contract still be enforced against the worker even though they won the harassment action?
Unless something in that harassment adjudication voids or nullifies that provision of the contract, in my mind, they are separate proceedings. And so, yes, I mean, the stay or pay is triggered for any reason or no reason, right? And so I don't see why a sexual harassment claim, unless it takes out the entire contract, which typically is not the case, why it would relieve them of that obligation to pay, that contractual obligation to pay.
So if, let's say, it's because of unsafe work environment and they decided to leave, well, or blow whistleblower, and so the employer for violating safety laws or something like that, that would not affect a stay or pay contract?
Not, I would not expect that it would, unless, again, there is something very specific about the stay or pay provision that is the reason the government agency came in, and as a result of the government action, that provision was voided. But if it's, quote unquote, merely addressing the subject of the whistleblowing content, not letting people take breaks or unsafe work environments, then no, I don't see why that would affect or displace the stay or pay obligation.
Well, I asked you to give us language, and so, it may be in the language, but you were saying you need to include some kind of protection against leaving for legitimate reason. Well, for reasons of violation of law in the workplace. Are you suggesting that the stay or pay contract, that we would require the stay or pay contract to provide such an exception?
Well, currently, the drafted language I have right in front of me does include a provision that says the provision does not require repayment if the employee is terminated without cause.
Yeah.
And I think the intent there is that if an employer just decides at a whim to fire you, maybe they're firing you specifically to trigger the stay or pay, right? That doesn't seem appropriate. I think you could just very easily revise that sentence to include, other instances that we want to protect against, like constructive termination, right? They're effectively making such a terrible environment that people have to quit, that they don't want to be the one to fire you. So I think that's a way to address these issues.
Great, thank you. Tom, do you have more questions? Okay. Other questions from the committee? I would say we have another minute or two. Is there any question of any of the witnesses? Gentlemen, thank you so much for your time and your work. We appreciate it. It's great to have you here. Come to Vermont sometime. And thank you.
Thank you.
Thank you so much.
Members of the committee, we're about to hear some testimony on Prop 3. No, wait a minute. A walkthrough and committee discussion on Prop 3. And then proceed immediately into introductions, just introductions of bills. Do you wish to take a 5-minute break now? Shall we take a break now? Why don't we take a break for 5 minutes and let's come back